Can I use copyrighted material in my own videos? It's a question I get on my platforms all the time, whether it's images, movie clips, or even other creators' videos. Because yes, believe it or not, there's actually been some copyright lawsuits on reaction videos. And most often we're talking about three things: rights, fair use, and public domain. And it's important to note that this is obviously for educational purposes and always will be, because copyright law is not a black and white thing, but rather is usually up to courts to decide based on the specific facts of a scenario. But here are the basics. First, copyright is actually enshrined in the Constitution under Article 1, Section 8, and then is fleshed out in much greater detail in the Copyright Act of 1976. The basics of copyright is that it allows the owner of whatever the material is to be the sole person to decide who is the one to get to sell, use, etc., whatever that material is. And there's really good reason for that from an intellectual property perspective and from a general business one, because in theory, it prevents people from capitalizing on others' hard work. Now, importantly, copyright law does not last forever. It's typically life of the author plus 70 years. Or if whatever the material is a work for hire, then it's 95 years from the date of publication, or 120 years from the date of creation. A little confusing, not what we need to get into today. Before we start, there's something about copyright that you need to know that most people don't understand, and that is it is automatic. You do not need to register with the US Copyright Office in order to receive protection. For instance, as soon as I put this video out there, I have a copyright in it. One of the things I used to tell my students in any IP class is that even in their notes that they make for class, that is automatically copyrighted once they write it down, even if they're writing down stuff that I say. Because yes, copyright covers material, but it covers that material when it's fixed in a tangible medium of expression. It's why, for instance, back when CDs used to exist, there were actually a whole bunch of different IP rights involved in that. Because you have the music, the recordings, you have the vocals, you have the way that things are put together and the composition, you have the little booklet that goes inside the CDs with graphics and the actual written words. And when I say the copyright is automatic, there's a reason for that, and also an important caveat. The reason being, it's really difficult for people to get copyright on everything, especially now. And the Copyright Office would need 1 million people in its staff just to be able to maintain them. However, there is a way to register copyright, and the reason for doing that is if you want to bolster your ability to protect it legally. Because if you haven't registered it, then essentially what you could get into is a fight over who actually owns a material. So high value things like books or movies are not going to want to say, I'm just going to put it out there and we're just going to claim copyright because I put it out there. They're going to want that extra layer of protection to be able to litigate in case anyone were to steal or misappropriate it. Now, at the end of that copyright term that I mentioned, the copyrighted work falls into what's known as the public domain. This is really important because I see people on the internet get this confused all of the time. Putting something online is not the public domain. In fact, putting something online arguably establishes your copyright in it because it is then fixed in a tangible medium of expression. So for instance, when someone steals something and people say, well, you put it online, you've put it out in the public domain. You have. In fact, what's probably happened is that you've put a stake on your copyright to it, assuming you have the ability to do so. So, all that in mind, here are the questions that you should ask when you're considering whether to use someone else's material. First and foremost, is the material covered by copyright? Which means you're going to ask two questions. First, is it in the public domain? Again, not the internet. If the answer to that is no, then you're going to ask, is the material actually copyright protected? Because copyright does not protect a couple things: facts, ideas, systems, or methods of operation. And there's some other stuff in there too. And one of the best ways to think about this is an algorithm, which by now we're probably all too familiar with. It is possible to get a copyright on an algorithm. However, protection for it is limited, which is probably one of the reasons why a lot of tech companies don't want to divulge what their algorithm is. And that's again because copyright protects the expression of something, the expression of the algorithm, not necessarily the algorithm itself. But the expression of an algorithm is usually how it appears for each individual user on an app. And that would be nearly impossible to copyright because the whole purpose of an algorithm is that it's different for everyone. And yes, there are exceptions for algorithms if they can prove something non-obvious in terms of a patent, but we're not going to get in there today. Most likely, the material that you're using probably has a copyright. So the next question you have to ask yourself is the intended use that you're using permitted? Which is basically asking, do you have a license to do whatever it is you want to do? Same reason why when you buy stock footage or stock video, you can purchase a license for it. Now, importantly, because most people don't realize this, there's a reason why when you buy that license, there are different prices to them. And a lot of people think, as long as I buy a license, I'm fine, so I'm just going to buy the cheapest license. Well, it's the cheapest license for a reason. It covers the least amount of uses. So for instance, let's say that you want to make something commercial out of it or want to put it on a platform for monetization. You're going to need a commercial license. Even then, you're going to want to read those terms and conditions on the commercial license that you're buying, because some of them still require attribution, for instance, which a lot of people forget. But reading terms and conditions is probably the most important thing you can do as a non-lawyer. And if you don't understand something, ask. The old adage of better safe than sorry is absolutely right. And do not go with better to ask forgiveness later than to ask permission now, because intentional copyright violations can cost you 6 figures per violation. Now, this license issue also comes into play when I get questions from students or even from commenters on here asking, how come then when I was in school I was able to use all sorts of resources free for my use? Well, it's probably because your school paid for a license on it, and probably you paid the school for that license in your tuition. It's essentially a massive library subscription. And even then, those library subscriptions come with terms of use, which don't typically grant you the ability to use it for any purpose you want, and tend to be fairly limited. Most often you've answered yes to is it copyrighted, and no to do you have permission to use it for your specific purpose. Because let's be honest, most of us don't have those types of resources or that type of time. And so here's the most important question, which is number 3. Is whatever you're using the material for covered by fair use? Fair use is one of the most misunderstood copyright provisions, because the actual legal code for fair use is very, very short. It essentially lists the 4 factors, and that's it. It does not describe how those factors are to be defined, which is why these things are usually not decided by individuals, but instead by courts once they get to a higher level. Another reason why your use of copyrighted material is always going to be, at some point, a guess. The fair use test is 4 different factors, and it is not definitive upon each factor, meaning just because you clear the hurdle on one factor does not mean that you don't have to worry about the other factors. First factor is the purpose and use you are intending to use the copyrighted work, including whether that use is for a commercial purpose or for a nonprofit or educational use. Now, remember what I said about 15 seconds ago of it's not just an automatic, I must be fine if I pass the hurdle on one of those factors? This is the one that courts used to say, well, hey, it's not for commercial use, so it must be fine. That's not the case anymore. It's now more of a holistic, balanced approach. That said, the first factor is arguably one of the most important. Now, some teachers think that just because they're using it in a classroom, it's automatically education. While that helps your argument, it is not an end-all be-all, because some classroom uses can actually be deemed to be commercial or for-profit. A lot of that is largely because, as you know, many educational purposes for content is for-profit, and having to distinguish between a classroom and non-classroom education is not something courts necessarily want to do, even though, to an extent, they kind of have to. The second factor is the nature of the copyrighted work. Now, in most instances, courts are going to say that non-fiction work is more likely to fall within fair use than fiction, and published works, meaning the owner has sought to distribute whatever the work is, are going to receive higher copyright protection than non-published. So, for instance, let's say that you're making an educational video. You can certainly claim this is for educational purposes, but if, for instance, you're in a monetization program, that claim is going to be harder to make. And even if you're not, your use of that work in an educational and not-for-profit setting might actually harm someone's ability to use whatever their copyrighted material is in a profit situation. We'll get into that in a minute. This is why we say that fair use is more likely to apply in situations such as news, because as we mentioned before, you can't copyright facts. However, you can copyright the expression of those facts. So it's not like you can just take a whole news station's broadcast and say, well, hey, look, it's just a bunch of facts, so it must be fine. Now, of course, what often happens is that people or creators want to be able to use a small snippet of something. That's where we get into the third factor, which is the amount and substantiality of the work that is copyrighted that you want to use in relation to the entirety of whatever that work is. The second half of that sentence is really important because, for instance, taking 30 seconds from a 6-minute short film is actually probably way worse than taking a minute and a half of a 90-minute film, because that proportion in the short film is actually a greater percentage than the proportion in the longer one. And substantiality typically means whatever the heart or the point of the work is. Reason being that some copyrighted material actually has a higher protection on whatever the point or the heart is than on some of the more extraneous things. Now, here's a really important myth that I need to dispel. I've seen a lot of comments from people that say, I always follow the 10% rule, meaning as long as whatever I take is under 10% of the copyrighted work, then I'm fine. That is not a law. It is a guideline that a lot of libraries and institutions have decided to follow, but it is not a law, and it is not a bright line rule. So if you've been following that as your end-all be-all, you should probably stop. And finally, factor number 4 is the effect of your use upon the potential market or opportunity for value of whatever the copyrighted work is. In other words, does your use of the copyrighted material impact the marketplace for the copyrighted material itself? This is a very confusing one, and many people incorrectly assume the following line of logic, which is my use doesn't impact the marketplace for that work. If anything, it increases the value of it because it lets more people know about it. This is, of course, often the line of reasoning used by the defense in copyright cases. It does not have an awesome success rate. So, for instance, when I see things like people developing sequels to series that ended, and they say, my work isn't impacting the original work at all. If anything, it's bringing more viewers to the original. While that may be true, the original copyright owner wants and maintains the ability to create, for instance, a sequel somewhere down the road. We see this a lot in the publishing space. Even if an author dies, the copyright is typically owned by the publishing company, and 20 years from now, they want the ability to be able to release a sequel. If your use of the copyrighted material does not fall within that fair use bucket, then you need to seek permission. Even if you think it does fall within that bucket of fair use, you should ask an attorney. They may tell you to seek permission anyway. Now, practically speaking, there are also some important considerations. A couple really important questions that many people get confused on. Contrary to popular belief, just saying I do not own the copyright to this does not strengthen your legal case. In fact, if anything, it typically raises red flags. But of course, you also can't not say anything. So you're basically back to square one, finding out if you have permission. 2, what's this whole thing about transformative use? In general, that fair use test that I just gave you is going to much more favorably view transformative uses, meaning you are doing something with the copyrighted material that turns it into something new. That might be commentary or criticism. That said, that does not absolve you. And as a practical matter, you should know that a lot of rights holders, especially on things like movies, tend to more actively assert their copyright abilities when whatever someone has done with the video is negative, versus if commentary on a film, for instance, is more favorable and uses a clip. Rights holders may decide that's not worth pursuing because it's good for us. Again, not a bright line rule, but in general, negative commentary does receive higher scrutiny from copyright holders. And remember, just providing commentary on something does not mean that you've made it fair use. 3, what about this Creative Commons license? This is kind of what I was talking about earlier. Make sure you read the terms on it. For instance, typically attribution is necessary, but it is not the only requirement. And finally, what about parody? Parody does receive an incredibly high amount of protection in the United States, but that doesn't mean that it completely shields you. And so it's important, again, that you're looking back to the entirety of that 4-factor test. Because remember, fair use is essentially a defense to a copyright infringement, which is to say, you admit, I did infringe on copyright, but I was allowed to because of fair use. It does not mean I didn't infringe. And that's really important, because if you're relying on the fair use test, you're essentially saying is, I have infringed, but, which is why every attorney in this space will tell you, make sure you're careful. And if you're using footage from the internet, make sure that it's from reputable sites with solid licenses. If you have any questions, feel free to put them in the comments below. Make sure to like and subscribe for more.